Good afternoon, good morning, good evening to everyone on the line. Welcome to the MER Sapient Contoural webinar, California Consumer Privacy Act, What, When, and How to Comply. This is Mike Salvarez. I'm the Vice President of Content Development at the MER Conference. And again, I'd like to welcome you all and let you know that we will begin in about 1 minute. Please hold on. Well, good afternoon and good morning to those on the West Coast, and good evening to anyone else in a different time zone. This is Mike Salvarez from the MER Conference. I'm the Vice President of Content Development, and it is my great pleasure to welcome you today to our MER Sapient webinar brought to you by Contoural and the MER Conference, the California Consumer Privacy Act, What, When, and How to Comply. There is a lot going on in the world of privacy, and this is a particularly important topic for all of us on the line today. So this is part of an ongoing series of webinars that we are producing for you. I'd like to acknowledge the Contoural team, and in particular Mark Diamond, for all of the wonderful content that they have been bringing to us throughout the year. If you've been on any of our webinars to date, you know that these webinars are extremely rich in valuable content. Thank you very much, Contoural, for doing all of this work and bringing this wonderful content to our audience. A few words about administration. This webinar is being recorded, and you will receive an email link later this week with a link to the recording of this webinar. You can share it with anyone that was unable to attend, or you can use it to replay it if you missed anything during the webinar. Also, we will allow questions during the webinar. Time permitting, the panelists and the presenters will address those questions. The way to ask a question is to type in your question using your GoToWebinar control panel. There's a questions button which will give you the ability to type in a question, and again, the presenters and panelists will, to the best of their ability, get to those questions. And if they can't, they will address them with you offline. Finally, the conference will send you a certificate of attendance that will be emailed to you tomorrow. That will be a document that will come from a link from GoToWebinar. And one last thing, this is an MER Sapient webinar brought to you by Contoural and the MER Conference, and I want to remind you that the MER Conference will be taking place in May the 20th through 22nd of 2019 in Chicago. I'll have a little bit more information about that at the conclusion of the webinar today, but I want to encourage you to think about attending that conference. If you have not been there in the past, please try us out. You'll be able to meet with Contoural and other industry experts and really get your questions and identify solutions there. So without further ado, let me introduce Mark Diamond, the CEO of Contoural. And Mark, the floor is yours.
Thank you very much. Today we're going to talk about the California Consumer Privacy Act, what, when, and how to comply. And for many of us, it seemed like just last month, although it was a little bit more than last quarter, that we got through one of the privacy regimes out there, which is the European GDPR regulations. And lo and behold, out of seemingly nowhere comes this new significant legislation regulating the privacy information of California consumers. We're going to say up front that we believe that this act is, first of all, very impactful. We believe that organizations need to do quite a bit to be able to prepare. Second of all, we're going to say that this is far-reaching, and we'll talk about this. We think this extends well beyond California and the impact of California. And third of all, we believe that this act is going to see significant more enforcement and have significantly more teeth than what we've seen even from Europe. Matter of fact, for most U.S. companies, we believe that the impact of this act, which we call CCPA, California Consumer Privacy Act, will be a full magnitude greater than the European GDPR regulations. And so to talk to it today, we've got a couple experts on the phone. We've got Tom Mighell. You may know Tom from some other webinars. Tom's an attorney. He's a certified information privacy professional. Does a lot of work helping organizations, both with information governance, as well as Greg Forrest. And Greg is the Chief Technology Officer, Contoural. Spends a huge amount of his day helping organizations with data security classifications, other areas. Welcome, Tom. Welcome, Greg.
Thank you very much.
Thank you.
So, Tom, we're not going to spend a huge amount of time going over every aspect of the Act today, but perhaps it's helpful if we start out just an overview for those who may only be somewhat familiar with the Act. What is the Act? How did it come about? What's involved?
So the Act is largely a response to the Cambridge Analytica scandal that took place through Facebook, where it was discovered that a company was taking lots of personal information and using it for analytic purposes. A ballot initiative arose in California that garnered a lot of support. It looked like it was going to be successful. It looked like it was actually going to win at the voting booth. And so the legislature approached and said, what can we do about this? And the initiative's sponsor agreed to remove it from the ballot, provided that the legislature agreed to pass this legislation. And literally they passed it in 2 days of debate and discussion and review. And that's, as lawyers say, that's how the sausage gets made. We are probably going to see the effects of a law that was put together so quickly in the coming months as it gets changed. We'll talk about that more in just a little bit. The purpose of this webinar is really not to discuss everything that's in the law, but rather how to get prepared for it. I do want to spend a little bit of time talking about kind of just a little bit on what is in the law. The penalties look deceptively small, $2,500 to $7,500, whether it's an unintentional or an intentional violation of the law. Typically, these actions are brought by the California Attorney General, but there is some private right of action. There is definitely a private right of action for data breaches where the damages are $100 to $750. Keep in mind that the law says that that's just the statutory cap. Actual damages might be higher. And when you multiply these by hundreds or millions of consumers who might be affected, if an organization has a data breach that affects millions of consumers, we're talking about potentially a lot of fines and a lot of penalties here. So this is not something to treat lightly. There have already been some changes. The changes have been, I would say, somewhat minor. First was to clarify that CCPA is very similar to GDPR in that it's already in effect, it has been passed, but it will not actually be enforced or be operative until January 1st of 2020. So companies, organizations have some time, not a lot of time, but some time to get ready for it. They've extended the period of time to pass regulations or to put the how to comply with the CCPA has been extended, interestingly, to July 1st. Not sure how we're going to have enforcement on January 1st, but the regulations won't be required to be in place until July of 2020. We'll see how that plays out. They've eliminated the notification requirement. Individuals no longer need to notify the Attorney General if they want to pursue a private action. We expect that plaintiffs' lawyers will be very interested in class actions and other types of lawsuits arising out of the misuse and violations of this act. And then finally, there's been some clarification around entities that may be exempted from CCPA. For example, organizations that are required to comply with Gramm-Leach-Bliley or HIPAA. For whatever reasons, if you have data that is covered by those acts, you may be exempt from CCPA. You may not. You may need to check with your legal counsel or look at the law and determine whether you have to comply with both. But in general, organizations who have to comply with those two do not have to comply with regard to at least that personal data with the CCPA. Next slide. So the heart of the CCPA are 5 fundamental rights that are guaranteed to all California consumers. The right, and none of this should really be a surprise, although the 5th right is new, relatively new, at least something different from GDPR. The rights are to know the personal information that an organization collects about them, to know to whom it's disclosed and whether it's sold or disclosed. If an organization sells or discloses or transfers it out of their organization, to access their information whenever they want to see, what do you have about me, to have that business delete the information on demand, and then finally, that they can't, consumers have the right not to be discriminated against if they exercise any of their rights. If they ask that their information be deleted or that something otherwise happened to it, they can't be treated differently than other consumers whose information is not deleted or who are pretty much giving up their rights or have not exercised their rights under the Act. Can't discriminate against them, and this is, I think, is going to be one of the interesting pieces to see play out about how organizations choose to treat consumers one way versus the other, or whether they will at all. Next slide. So who is impacted? Well, the law is very broad, and as you will see, that's why I've made this description here intentionally broad. If you are a business that collects or sells personal information from or about California consumers, then you may be required to comply. Now let's break that down and define each one of those, because the Act defines all of those. A business, to qualify as a business under CCPA, you have to answer yes to one of the following questions. Do you either have annual gross revenues in excess of $25 million, or do you annually buy, receive, or share personal information of 50,000 or more consumers or households or devices? Or does 50% or more of your annual revenue come from the sale of personal information? If you can answer yes to any one of those questions, then likely you are a business that will be required to comply with the CCPA. Likewise, collect or sell also has broad definition. Collect means buy, rent, gather, obtain, receive. It doesn't mean there's a monetary component to that. However you come by that information can be collection of personal information. Selling could be selling, renting, releasing, but it doesn't have to be monetary either. It can be disclosing or disseminating or making available. So whether you take personal information in or you send personal information out, that qualifies as either collecting or selling. Personal information, again, a very broad definition. The definition actually says that personal information is information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So I don't think they could have made it any broader. Anything that could possibly relate to personal information qualifies. Notice I ended with or household. That is different from, say, GDPR and other privacy regulations. This applies not just to a consumer, but also to households. And then finally, consumers. What is a California consumer? Well, a California consumer is what the law considers to be a natural person who is a California resident. A resident includes every individual in California who is there for other than a temporary or transitory purpose. So if you're there other than for school or on business or some other reason, if you live there, you're a California resident. But it also applies to people who live in California but may be outside the state for a temporary or transitory purpose. So if you are a business and you do not regularly collect information on California consumers, but a California resident walks into your place of business on vacation and you take their personal information, you may be required to comply with CCPA. It's that broad. It's something you really need to pay attention to. Next slide. So the law is not set to go into enforcement until 2020. During that time, we expect that there will be some changes. The Attorney General's office is going to issue some regulations. They're going to hopefully clarify confusing parts of the legislation. We're already seeing amendments to the law to help clarify. We would expect that there may be other amendments that might be in response to lobbying or discussions with people who are going to be affected by the law. We'll likely see further guidance on how to comply with the law. What is almost certain not to change are the rights. I think that the 5 rights that are granted to all consumers should stay the same. It will be interesting to see whether or not the definition of personal information changes. There's already some level of lobbying going on, particularly I find it interesting that the advertising technology industry is looking to exempt both IP addresses and browser cookies from the definition of personal information, because that's what they deal in primarily. I don't think we can expect a lot of changes here either, but it'll be interesting to find out. And finally, were already a lot of other California privacy laws that were on the books when this one was passed, which are likely now either in conflict with the CCPA or at least have some overlap or will make enforcement of the CCPA confusing. So I think we should expect to see some of these older laws repealed or modified so that they come more into alignment with the CCPA. At least that would be the hope. And the question that some of you may be asking, is this just California? Well, California does tend to go where other states are hesitant to tread. The state has been very proactive in passing progressive legislation that doesn't always go over so well in other parts of the country. Privacy, I think, is a different animal, and I think it's an increasingly important issue for everyone. Data breaches are more common. Hackers are a worldwide phenomenon. The Cambridge Analytica, every day we hear of a new privacy breach on some social network. This is just too big of an important topic, which is to say, let's not be surprised if this is just the first among many such privacy laws. Now, what's interesting is that in the past couple of weeks, there actually have been hearings on Capitol Hill, largely driven by corporations affected by the California law who don't want to comply with it. They are lobbying Congress to pass what would in effect be a watered down privacy law, for a federal privacy law that would then preempt all the privacy laws in the country. Given this current state of Congress these days, I would be very surprised if we see a law coming out of the federal government anytime soon. But again, something to look at, because this is a hot topic and this is something that all legislatures are looking at. Now, we've had a lot of people tell us we're ready for GDPR, or at least we're still trying to get ready, even though the enforcement date has come and gone. Can't we just use the work we're doing for GDPR to comply with CCPA? The answer to that is yes and no. There are definitely differences in the CCPA that are going to make how you respond and how you comply slightly different from GDPR compliance. As you see here, the scope of CCPA really is focused on privacy rights. It's focused on organizations disclosing information to consumers and being transparent about what they collect. GDPR was a much more omnibus. It's a much more omnibus regulation. It covers a lot more. It's more prescriptive. It's just a bigger law in general. Personal information, the definition is broader. It's, as you could tell from the definition that I just described, it's a very broad definition that, again, includes households and devices instead of just individuals. The rights to access and deletion tend to be a little bit broader under CCPA than GDPR. CCPA doesn't care very much about security as long as you secure the information, whereas the GDPR is much more prescriptive and saying, here's how you should be protecting the information that you collect from individuals. The disclosures, where CCPA has more prescription, GDPR leaves it up to you more than California does. Data sharing is also interesting. GDPR, there's been a lot of conversation about transfer of information outside the European Union and what is an organization, a country that has adequate protection measures to personal data. California privacy really is only interested in transferring information to third parties and doesn't pay as much attention to where it's going as to the fact that it's outside of the organization that originally had the personal information. And then finally, there are a number of things that the GDPR does not require, or does require, that CCPA doesn't cover, and we're a little surprised about this and are going to be interested to see what happens in the coming months about whether these will ever become requirements or how they'll be handled. GDPR requires privacy by design. when you're developing a business process or a new technology, building privacy in at the front end rather than coming in at the back end and retrofitting it. Conducting data protection impact assessments on those processes, on those new technologies, to understand how they will impact the collection and use of personal information in your organization. There's a California breach law that covers breach notification, so it's not included in the CCPA. And then there's not a requirement, although we're going to talk about why we think it's a good idea, there's not a requirement to appoint a data protection officer under the CCPA, but we're going to discuss later that we think it's a good idea to have someone in charge of your privacy program, or else nothing's going to happen with that. So how do you get ready for California privacy? We think the best course to develop is to develop an action plan for dealing with your privacy information. This is a roadmap for and a layout of the steps that we think that companies should take to be fully ready for California privacy and beyond. Some of these are not explicitly required by CCPA, but we believe that to get from one step to the next, you need to address each of these steps in the action plan in order to be compliant. The four major areas are assessing where you are, understanding what your current privacy needs are and what information you have, laying the foundation, developing all your documentation, making sure that your security and privacy controls are in place, then implementing it. Make sure that you have implemented the right technology to be able to protect the information, to be able to handle the consumer access requests that are sure to come later on. And then finally, when you execute it, it's about training individuals on both the ones who are handling personal information as well as all employees. And then finally, dealing with all that legacy personal information that you may have that needs to be either destroyed or adequately protected, moved to the right repository. Underlying all of that is a good organizational structure that helps to manage your privacy activities. We'll talk about all of these in the slides to come. So first step, assessment. We believe very strongly that the first activity an organization should do is to really take a look at where you are. And the reason for that is that if you just read the California Consumer Privacy Act today and you said, okay, well, I think I need to do this, and I think I need to do that, and I probably need to do this, then you're probably going to approach this in a more ad hoc fashion. Maybe not doing things in the right order, maybe not thinking of everything that you need to do. Conducting an assessment is really the best way to get that done. It helps you understand what are the right things to do and what is the right order that you need to do them. Let's look at the next slide. The assessment itself is a fairly straightforward look at how you currently manage personal information in your organization. First, it's about discover. What are the types of personal information that you store? Where is it stored? How do you classify it? Why do you classify it the way that you do? It's really about understanding what you have in your environment in terms of personal information. The assessment then looks at your current policies and procedures for managing that information. How long are you keeping it? How are you currently respecting individual rights regarding their information? How do you manage risk around keeping that information? What types of management protocols and infrastructure do you have around personal information currently? Related to that is protection. The next step of that assessment is to understand how personal information is protected in your organization. Are you integrating privacy into new technologies? Do you have a data breach response plan or incident response plan, and are you executing it and practicing it to make sure that if a breach occurs, you are ready to respond? And then finally, one step that we find a lot of organizations either don't get time to or overlook is how do you communicate your privacy program? How do you respond to a data breach? How do you measure compliance with your current privacy policies? Do you manage compliance with your privacy policies? This audit and monitoring function is something that organizations really struggle, but we think that it's important. Figuring out not only do we have a policy, but how do we actually do it? How do we actually execute it, and are we executing it is tremendously important. Once you determine where you are, the next step really is to understand how do we get to the next place. What is our maturity level right now, and what do we need to fix any gaps that we found? So you create a remediation plan, you create a roadmap for prioritizing those things you need to do to comply with the California Privacy Act. And then the other things that can actually be done further down the road. It's figuring out what needs to be done now to comply, what can wait until a little bit later. We're going to talk about a lot of those things in this webinar, but that's really your time to figure out, here's my roadmap and here's what I need to do before January 1st of 2020. All right, the next step that we recommend, and one that's going to really come into play a great deal with CCPA, one that will essentially be a requirement, is that personal data inventory. This is essentially understanding where all your personal data is located, how it's managed there. Let's move to the next slide and talk about it a little bit. Greg, let's get you talking in this webinar. What are some of the challenges really with completing or creating a personal data inventory?
Well, I think, most of us figure that our personal information is in customer-facing systems, sales systems, customer master systems, systems that support customers, and so they're in applications. And we figure, okay, it's pretty easy. We've got 3 or 4 repositories. We're going to put those repositories under control, and everything will be okay. But the reality of most businesses today is that reports, extracts, business intelligence tools take information out of those systems and move them into spreadsheets, Word documents, PDF documents, all kinds of other formats where they then become individual files. And at that point, they can move anywhere and everywhere in an organization, from network shares to individual devices to mobile devices, moving around through email. So basically what happens is that personal information that was nicely locked inside a system and we thought we only had it a few places that we had to deal with suddenly becomes everywhere. And that really compounds the issues of being able to find, produce, and delete that information on demand.
So we recommend taking a 2-pronged approach to the data inventory, because it's not simple enough to just say, what are the repositories? Here are all the different repositories where personal information might be held. We're never going to catch them all. We're never going to figure out everything about where that personal data goes if you start with that approach. So first, think about the processes. What are the processes that result in the collection of personal information in your environment? How does it come into the company? How do you move it through the company? And then how does it leave the company if that's where it goes, if it does leave? That, once you understand the process, then in each step of that process, you can identify the different repositories where it may live all along the way. At that point, once you've identified the general process, the general workflows, then you can start to do a more in-depth analysis of the repository. Greg, you want to talk a little bit about that?
Yeah, so this is really figuring out, how do you classify privacy information in that repository? How do you do search for information in that repository? How can that information be deleted? How can it be protected? How can it be kept from leaving that repository if that's your design from a business perspective? So at this point, once you've done a workflow analysis and you have figured out all the places it can go, then you start looking at where it lives to see what controls you have and what controls you might need in the future.
So you've figured out what you need to do. You've hopefully got a roadmap of where you need to go. You now have hopefully an inventory of the personal data, how it comes into and out of your organization. You've probably hopefully taken a look at those repositories and figured out, are they all capable of managing the information the way that we need them to comply with CCPA? Let's make sure that our privacy foundation is in place. And this is really both a process and a technology aspect to building your foundation. It's developing privacy policies and procedures, and then tightening or creating your data security and privacy controls. Next slide. So you're clearly, if you have a privacy policy, you want to update it. You'll need to update it to make sure that it's addressing the current rights of California consumers. If you have privacy notices on your website, you'll want to update those too. But it's more than just that. You'll want to look at procedures that are centered on managing personal information. Do you have data security classification standards? If many organizations we talk to have them, but actually haven't implemented them yet. Are you implementing them? And if so, do they take these new privacy regulations into account? Do you have a data breach or incident response plan that's needed? One of the things we'll talk about a little bit later is the fact that you'll need procedures in order to handle the requests from consumers that come in for their personal information. So developing these procedures is going to be a really important part of this kind of establishing your how to comply with CCPA. One of the things that is certainly required by CCPA is that every company must install or place on their website a prominent link or button that basically says that with one click, a consumer can instruct an organization, you may not sell my personal information. So with one click, someone's going to be able to request that. There clearly going to have to be some type of process or procedure built around processing those opt-out requests. So a lot of things to think about.
So again, sorry about that technical glitch. Welcome to the world of technology. So we're going to give it back to Tom Mighell. Tom, do you want to continue talking a little bit about, you're talking about privacy policies and procedures and what are some of the changes people need to make, and as we were.
Well, I think actually I was done with this. I think I'll just finalize this out by saying that really before you get started, you've got to make sure you have the policies and procedures in place. That makes for a good foundation before you can begin to execute on your privacy requirements. But likewise, you need to make sure that the privacy and security controls you have in place are adequate. So Greg, over to you. Greg, you on mute?
Thank you, Tom. I was indeed. So while these controls may not directly affect your ability to produce information back to consumers, this is what it takes to keep information controlled enough to be able to search it, find it, produce it, and delete it on demand. So the first is basically those things that prevent or control movement between repositories themselves. File sharing applications such as Box and Dropbox and Google Docs and Drive, and those types of things are fairly prevalent in a lot of organizations and maybe not controlled too well. So having tools that can look on the outside to see if people are transferring large amounts of data are quite important. Likewise, virtual desktops will keep information from being stored on things like laptops that can be lost and have privacy information on them. So there are definitely ways to prevent that movement. Access controls are extremely important. If you've got your primary privacy systems and they're wide open to too many people that can take extracts, or perhaps the access to take extracts or run reports is very wide open, that might be a place to look at your security controls. Obviously, encrypting data when it's on an endpoint, i.e. when it's on a laptop, or when it's in a container in a phone or on an iPad. This is also very important so that those devices get lost or stolen, the information can't be read. Preventing data from being shared, printed, or stored elsewhere. Information rights management is something that's been around in certain systems for quite a while, but is now getting a more mainstream kind of look in the world. What this does is it allows employees to read a file, but not necessarily to print it or copy it or save it or move it or put it in email. So this is an emerging area that Microsoft in particular has spent a lot of energy on in the last year or two. And then finally, obviously, you're going to need to be able to scan repositories for privacy information that isn't where it's supposed to be. This will tell you whether things have links to places that your policy says information shouldn't be stored. So these are kind of the beginning pieces of the privacy and security enhancements that are necessary to kind of lock down your environment and make sure you don't have such broad exposure. Next slide.
All right. So you've got your foundation in place, you've got your policies and procedures. Hopefully you've implemented those controls that Greg just mentioned, or enhanced what you need to enhance. Really, now it's time to start implementing, and we think it really starts out with some applying good information governance practices to the repositories and tools that you have. Greg, you want to talk about that?
Absolutely. So if we can move on to the next slide. So, you know, the question is, we just talked about all those places where it can live. So if personal data is living in ungoverned locations, and some of those are extremely difficult to go ahead and search and produce information from, how do we lock things down? How do we make sure that our information lives in a system that does have the type of controls, that does have a good search engine associated with it? And that's really the first piece, which is, next slide please, either a data placement strategy, or some people call it a data classification strategy. And what this really means is moving data from systems that don't allow for things like tagging or metadata or labels into systems that support that type of infrastructure, so that we can place that employees can properly follow a policy and classify information as containing privacy data, as containing sensitive data. You know, so it is basically what we're talking about is moving from systems that have little or no controls that allow for a lot of disbursement of data into systems that control them much tighter. Next slide, please. So really the decision here is, do we let everything stay where it is and try to use tools to control what's in those basically uncontrollable systems, or do we move it into a governed environment? And frankly, if you make that move, there's a whole lot of good things that can happen. It makes it much easier to search. It makes it much easier to produce so that you can show consumers what you're storing. Those systems already contain classification and protection capabilities. They allow for a granular deletion of information by a very narrow set of patterns or individuals. And they really reduce your overall risk as well, because they tend to be much more hardened systems than the individual endpoint devices or file shares and those types of things. So again, you know, the real issue here is it time to finally do the right thing and put your information in governed areas with privacy as the primary driver, and get all the other benefits that come along with that movement? Next slide, please.
So the second part, the next part of that implementation is you've moved everything to the right location. You've put it in a place where it can be protected, where it can be organized, where it can be searched and discovered in a way that makes sense. That is the setup to making sure that you have the ability to understand and get to and process consumer access requests, which are certain to come. They're coming already in the GDPR, and we expect that it would be no different under California privacy. Next slide. Because CCPA gives consumers the right to either access their information or just have it deleted, you will need to have a process in place to respond to those access requests. CCPA requires that you make at least 2 means available of making that request. We expect that the 2 most common will just be a toll-free number or a link on a website. But no matter what you decide, you can rest assured that consumers are going to try to contact you everywhere that they can to request access to their information, whether that's through your social media site. If you offer tech support, they'll try and do it there. They might call numbers that they find on your website. They might find email addresses to people in the company. Even if your answer to all of those is, please submit your request through the proper channels, you still need to have a process to respond to those requests. So the first thing you do is, how do we intake the requests? how do we track them and understand what requests we have? But once you actually do have a proper request, once it's submitted the right way, you need to be able to verify its authenticity. Did it come from the data owner? Is it someone who's trying to steal that information or some type of identity theft? Having that authentication process in place is the important next step. So we've got to be able to intake the requests. We've got to be able to authenticate them. Once we determine that the consumer is making the request, then those processes that we have, we need to be able to search the information. We need to be able to produce it if they've asked for it. If we need to find a way to produce it, and the format in which to produce that information. And then if they've asked for deletion, there needs to be a defensible, documented way on how that information is officially deleted. Each one of those processes needs to be documented and understood within the organization. And you're gonna have to do all of this within a 45-day time period. That is the deadline to respond to a request, a consumer access request. There will be some circumstances that would extend that 45 days, but let's count on 45 days as the baseline right now and understand to work to that deadline. That's why having the data placement that Greg just discussed is so crucial to this particular part of the process. If your information tends to be all over the place, you will lack a good way and a good method of finding, searching it, either producing or deleting it. It's just going to be much more difficult if you can't find that information. Now, the next piece is execution, and these are sort of two not completely related steps, but we think are both very important. They are things that we see happening in any information governance program, but also privacy as well. And the first is change management and training around privacy. Next slide. Training is not specifically required by the CCPA, but we would argue that you must train your employees, that in order to ensure compliance, you particularly must train the employees who are either one, managing the personal information, or two, going to respond to the consumer access requests. At a minimum, those people need training. Not only does that help you to comply with the law, but in the event of a data breach, in the event of a violation or alleged violation, you can point to that training as proof of good faith efforts to comply. If you don't train employees, if employees say we really didn't know how to handle this information, that tends to go the other way. That shows a lack of good faith, points toward non-compliance. Whether or not individuals comply or not, providing the training goes a long way to showing that you've done your part to make sure people know what they need to do. We also think that it's a good idea, if you're not doing this already, to introduce training to all employees on privacy concepts, why they're important to the organization. Why is privacy important? Why do we as an organization protect personal information? How should we respond if there's a breach or some other disclosure of personal information? What does the average employee need to do? Helping your employees to understand the types of information that need to be protected, what you as the organization are doing to protect it, very important, because some of that personal information actually belongs to your employees. They will be glad to know that you've got their back on protecting their information. And then showing employees how they can help to protect the information is really going to help with compliance, not just with CCPA, but really any privacy regulation. Making sure everybody understands it helps to ensure a lot better compliance with your privacy program. So the next piece, we've covered the information in place, we've covered the active information that we've got, but sometimes when we deal with our information, there's a lot of legacy data or records that are left over that nobody really wants to talk about or deal with, but we think it's really important that you do that. Greg, why is that important?
So certainly the regulation itself says you only need to go about a year back in terms of recently collected information, but that regulation is going to be ongoing, and eventually what backs up is going to be something that you're going to have to deal with. But more importantly, the more legacy data that you have, the harder it will be to search it, to control it, to classify it, and to tag it. So again, it's time to take it from where it lives and put it to where it should be, and to remove what you don't need. So for sake of argument, if you have big backup tapes that have 7 years of backup of all your privacy applications, and you delete the information from the primary system, but it's still on hundreds of backup tapes, you actually have an exposure. So in some cases, you will need to indeed do legacy privacy remediation and perhaps even change some of your policies in the way that backups are done. But most importantly, you need to, again, get it out of places that can't be well controlled and start removing it as much as possible from those places, and to follow a good record retention program so that it doesn't stack up for the future. So that's really the reason for legacy remediation. And again, it may not be your first priority, because your first priority should be the ability to search and produce information and delete it. But eventually this is going to come back and be your largest problem if you don't address it up front.
So if you'll notice this roadmap, all along the bottom and underlying all of these steps is having some type of organizational development or people responsible for administration of your privacy initiatives, your privacy program. Next slide. This is also not required by CCPA. There's no requirement that you have a privacy officer. There's no requirement that someone be required to report to the state of California on behalf of your organization about what your efforts are. There's no requirement that somebody be designated for consumers to talk to. But if you're developing privacy policies, if you're developing procedures, if you are actively trying to comply with the California Consumer Privacy Act, you have to have someone to administer them, someone who is promoting them. Otherwise, it's just like we've talked about in other episodes of this series. If you don't have someone, if you don't have an information governance or records management organization and someone to enforce that, no one's going to feel obligated to follow the rules. What you see here is sort of, a high-level view of a best-in-class organizational structure. You're going to generally have some type of chief privacy officer or privacy manager, someone who is largely responsible for overseeing the privacy program. In this case, we'd recommend that this person report to a more cross-functional information governance steering committee. That's because privacy is part of the information governance umbrella. Then the IG steering committee should also have some responsibility to deal with privacy the same way it's dealing with records management and litigation readiness, information security, and the other ways that information is managed throughout the organization. Because that privacy manager, chief privacy officer, what have you, cannot always do it alone, you may also want to identify compliance leads for your departments, for your functions, the people who would have subject matter expertise in privacy or would understand the types of information managed in that area and how to protect it and how to comply with the company policy and with the relevant regulations. It may be instead that instead of a compliance lead, you simply need to identify a coordinator, or we've said here, privacy champion. People in each department that can do the basics. They can answer questions about the privacy policy or the program. They can help with training if necessary. They know enough to kind of talk about the training. And then they help to ensure compliance, but they may not be those true privacy subject matter experts. Either way, having someone on the ground level to help out a manager is a great idea, because that manager can't get around to everybody on their own, and having somebody who knows the records in that group, what that group does, how they manage it, it can really be an effective way to deal with this particular information. Next slide. So Mark, I'm going to bring you back into the conversation. What are you have seen ways in which information governance programs fail. What are some of the risks that we're seeing to how maybe an implementation of California Consumer Privacy Roadmap or Action Plan might fail or be compromised?
So this is a tricky act to comply with, and as we alluded to, there's a lot there. And likewise, there's a lot of potential pitfalls out there. Let's just go through some of them. These aren't obvious. This is not an exclusive list. First one is policy-itis. We saw this to a large extent with European regulations, GDPR regulations. and let's spend a lot of time figuring out the policy. Well, we can't put the policy together because the legislation may change. Oh, we need a policy. And we see these organizations either going over again and again trying to create these super detailed policies, somehow thinking that if I've got the world's most up-to-date policy, that's going to make me compliant. The problem is when they get so focused on the policy, and by the way, this is often fed by law firms because they want the business around creating policies. The policy is developed to the exclusion of actual execution. CCPA is an execution-focused legislation. If you don't, litigators and class action attorneys will be going after you. And so it's really important you be able to do that. And the other good news about CCPA is, at least from a policy perspective, we look at it much simpler than some of the issues that organizations faced under GDPR. So yes, the policy may change. Yes, the laws may change. The Attorney General is going to amend it. We may have some other changes associated with that. But by and large, we think that the bulk of what needs to be done will remain intact through execution. And so don't get super hung up on your policy. The next one is siloed approaches. We saw this with GDPR too. Maybe you have a privacy group, and they are or not, or maybe you just have IT, or maybe you have legal. This is really a cross-functional effort because it involves handling information, data, and documents across the enterprise, but also engaging employees. And so don't try and do this alone. We've talked about this in some of our webinars on how having a steering committee, bringing groups together. This is equally true for California Consumer Privacy Act. Sometimes there's a tendency saying, well, we just have our policy, but when we need to have a request, we'll go find the data. A very manual process, or we'll figure out some way at the time to be able to identify what we have where. Greg talked about you really want to put the effort in ahead of time, not for everything, but for good bulk of it, because we're expecting a significant amount of privacy requests out there. And again, it's going to vary from organization to organization, and this gets you up a whole lot of time. And so to some extent, what we're saying is think about putting in some of the work up front, getting your data organized. That's going to, and avoiding having everything as a manual and workable process. And the final one is starting too late. I can't stress this enough. We're already working with a number of clients that are well into starting and executing their program in this area. If you spend too much time, we all, in the world of European GDPR, we had years. We actually, looking back, we were doing a presentation at GDPR in 2014. It's 2018 when it actually got executed. Here, we've got a little bit more than 14 months. So there's a lot to be done here, and don't start too late. Don't actually just go out and wait for perfect. So here's some of the areas that we see organizations need to look at. We got some questions. We're going to answer some questions. We caught up a little bit. Again, sorry about that technical glitch. Just real briefly about Contoural. For those of you that don't know us, we're the largest independent provider of information governance. We do work around privacy, records management, litigation readiness, defensible disposition. We don't sell any products. We don't store any documents. We don't even take referral fees. We're cross-functional. We're very flexible. We work with many, many organizations, 30% of the Fortune 500, federal agencies, other one. And we obviously, our focus is on execution. That's of what we do. Now, we've done a number of these too. We're also offering a complimentary on-site seminar. Many organizations, we don't even know what this is, or how do we get started, or who do we engage? We've got a good first step for you. We offer a complimentary CCPA on-site webinar coming on seminar, sorry. We do a go on site, usually a couple hours, not a sales pitch for us, but it's a good way to get everybody aligned saying, what is this? Why do we care? What do we have to do? And you've seen some of our approach and some of our content already today, but it's a good way for building a consensus. Email us at info@contoural.com if you're interested potentially in having us do this. Likewise, we offer a variety of CCPA services, assessment and roadmaps, organizational structure, data inventory, a lot of work on that. Policies and procedures. We can do part or a whole suite of services around getting you ready for CCPA. By the way, you'll notice some of what we've talked about, you're going, gosh, that sounds a lot like information governance. So the trick to this is we think much of this is related to information governance practices. This is a specific case, but many of the practices we've talked about in the past we've seen out there. And likewise, we've got a couple white papers. Email us. Really good content that talks about how do you get started? What do you do? What about the law? What are the steps out there? Again, info@contoural.com. We have the white papers. All right. Before we have questions, Mike, you want to go a little bit about some of the upcoming events?
Yes, thank you, Mark. And real fast, we have a number of webinars on the schedule. You can see them here, beginning with the next one just in a couple of days, October 18th, Information Management Privacy in the Financial Sector. There'll be a whole panel of experts there to talk to you about that topic. November 6th, Contoural will be back with the next webinar in their series, the Legacy Data Remediation. Also on December 4th, Contoural will bring us Catherine Hilton, and she'll talk about information governance, organization development, and that will be sort of towards the end of the year, and it's the wrap up of the Contoural Information Governance series. And finally, on December 6th, Mark Diamond from Contoural will join Michael Ruddy from Micro Focus, and they'll be talking about governance for mobile and social media technologies. Want to thank you all for sticking with this. Want to thank you all for rejoining the webinar and apologize for the technology glitch that we had. Mark, back to you for any final words.
Well, just time for a couple quick questions, and we'll see if we can hit these really quickly. One of them is, right now, state and local entities are not covered under CCPA. Do we expect that to change?
I do not expect that to change. No, I think that they've made it apply to who they're going to apply to. I think if we see changes, it'll be rolling back requirements on who it already applies to. I don't expect to see any new added.
I'm going to disagree with you a little bit. And well, the short answer is we don't know. If you look at the original breach legislation that swept across the U.S., that was based on a breach of the state of California employee database, and that actually started because of a breach on a California entity, the state of California. Other states may or may not exclude it, and if federal legislation comes through. So today, no, but keep a close eye on it.
The main reason why it won't happen is that state and local government agencies control or handle so much personal data, and they are usually built into the exceptions for the rule that these rules do not apply if you handle personal data for a governmental function. And so that's my main reason for thinking that they're not going to change it, because they're actually part of the exemption.
How convenient if you're
yes.
So again, we don't know, but you got some good opinions there. The final question is, how does this affect law firms? We can certainly collect personal information, but we don't sell it. Does CCPA apply to us, or should we just use it for guide for handling and retaining information?
I'll go back to the same requirements. If your law firm, if you can answer yes to either, we make over 25 million a year in revenue, we collect information on 50,000 people per year, or 50% of our revenue comes from selling personal information, then you apply. I suspect then it applies. I suspect that 25 million revenue would be the one that might apply to the law firm. Certainly, if you make that, if you have revenues over that, I would argue that it will apply to you. So go and look at the law and understand how businesses are defined in there to see whether or not a law firm qualifies.
And data under legal hold is not required to be deleted, but if you have a past case that has been adjudicated and you still have data under legal hold from a client that has personal information, they could legitimately say, no, you got to delete that stuff now because there's no reason to retain it. So
that's right.
Interesting. Well, we are out of time. And I want to thank Greg and I want to thank Tom for some really good input today. Thank you for the questions. Take a look at our white papers, take a look at our on-site webinar, and really thanks to MER. They've been a great host of these conferences, and they've done a lot of good work on that. So thanks, MER. And with that, I'll hand it back to you, Mike.
Thank you, Mark. Again, everyone, thank you very much. Enjoy the rest of your day. Please consider coming to the MER conference May 20th through 22nd, 2019 in Chicago, and we'll see you all again on the next MER Sapient webinar. Thank you very much.